Alex here with part 6 of the My Docket series on Corazon Real Estate, and this is not going to be a very long video. In fact, I think the next 4 are all going to be pretty short. It looks like each of the videos goes over either 1 or 2 documents. I can tell more of my experience was applied in this case, as I didn't do what I did in the earlier portions of the high conflict child custody case, which was file too many documents, and so things were a lot cleaner, more concise. I believe this video involves a motion to require the landlord to obtain counsel. The reason why is because there's a rule in Nevada that business entities cannot be represented in proper person, and in this particular situation, the landlord is a business entity. It's a corporation, a domestic corporation in Nevada. And just in case people are wondering, I didn't personally have an objection with what the landlord was doing. Of course, I'm representing myself, so why would I? And in fact, I can sympathize with what the landlord was doing, because he probably didn't figure it was a great idea to spend thousands of dollars on attorney fees over such a small dispute. But the problem and the concern that I had was that a judgment entered against this particular landlord for representing his corporation might be deemed void at a later date. My concern was that since the landlord didn't have the authority under Nevada law to represent the corporation, that even if I won the case, that somehow, some way, after the fact, he may find a way to void the judgment on that basis. So that was my concern, and so I did my research there. And in fact, I bring that up repeatedly, not just in the motion, but I even bring it up to the Supreme Court. I think at this point, all we can really do is go into what I have filed. Here we have my motion to require Corazon Real Estate to obtain counsel. Standard introductory paragraph here indicating that I am appearing in proper person and filing a motion to compel Corazon Real Estate to obtain counsel. Factual background is pretty short. On the 20th, I filed a complaint, and on October 12th, Corazon Real Estate filed an answer by and through its president and secretary, Charles Chinichi, in proper person. Summary is also relatively short. I have the utmost respect for this landlord's intent to personally represent his corporation, as I, whom myself is unable to afford counsel, understand the frustrating aspects associated with retaining counsel, including the loss of control in one's own case and the massive costs associated. However, I would even go as far as to say that I don't have a personal opposition to the landlord representing itself through its president, and that if the court will permit it, that Corazon may proceed accordingly. Argument: we got a local rule. Corporation may not appear in proper person. I didn't even know about that. But what I did know is this case in RE discipline of Schaefer, Supreme Court of Nevada stated that a legal entity such as a corporation cannot appear except through counsel, and they reiterated that again in Sunday versus Contel of California. Supreme Court once again said, this court, however, has consistently required attorneys to represent other persons and entities in court. Non-lawyers generally may not represent another person or an entity in a court of law. Oh wow, a third time. Salmon v. Newell. For the third time, the Supreme Court has stated that a person is entitled to represent himself in district court, but no rule or statute permits a person to represent any other person, a company, a trust, or any other entity in the district courts. Hearing, I'm not requesting one. And conclusion, I see the irony in citing SCR 44, which allows me to represent myself while simultaneously attacking Corazon's attempt to do the same. But I reiterate my personal non-opposition to Corazon proceeding in proper person. It is only due to my concern that this issue will eventually result in a stay of proceedings, or at worst, an issue at appeal that may result in a reversal and remand, that I find myself compelled to bring it to the court's attention as soon as possible. And it's also convenient for all parties and the court to take note that I filed on September 20th a notice of extension to file answer due to the fact that I am moving out of my dwelling unit, which is the subject of the case. Declaration, which is me indicating that all of the facts alleged in this document are true and correct. certificate under Rule 5 service indicating I mailed this document to the landlord, a list of exhibits, and this is Exhibit 1. Here we have Corazon Real Estate's business entity information indicating that they are in fact an active domestic corporation. Going into the aftermath, I filed one document, but it was a free filing, so I incurred $0 in costs. My opponent, the landlord, didn't file anything, so we incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. Even though he doesn't have an attorney now, he will eventually be forced to get an attorney, at which point they will probably have put a little bit of time into reviewing this motion. I highly doubt they put more than 15 minutes into it, so I'm going to go ahead and say at the rate of $250 an hour that's going to come to $62.50 in attorney fees for the landlord. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.